सब दोस्त लोग होता है एक दूसरे को शेयर कर देते लाइन वो सब मेट्रोपोलिस की ऐसी होता है तो जिसका लाइन है उसी लाइन में उसी को देगा सिविल लाइन में सिविल को देगा हम लोग देगा बस आपस में अंडरस्टैंडिंग होता है आपस में डिसिबल पूरा एक एसोसिएट तक बना के रखा है हाँ उसी में सब लोग होता है बहुत वेरी गुड वो एसोसिएट और बिल बना के देते हैं जूनियर फीस दिस मच सिटीजन फीस ट्रेडिंग फीस दिस मच बना के बिल दे दिया करते नहीं हो इसको भी सैलरी करते और अब यकीन नहीं करेगा जितना अमाउंट पैसा कपड़े भी देखो जो रेंट कोड में तो रेंट कोड में फुर्सत ही नहीं है
Item number 1.
Any mention or no mention?
I'd like to mention item 10 and 11. Item number 10 and 11.
What is 10 here?
Respondent number 6.
What is this matter about?
Suspension matter, Your Lordship.
Oh, that school.
School matter.
Can you have it after 3 weeks, Your Lordship?
Why?
Can you have it after 3 weeks?
Why?
Your Lordship,
What matter?
Mr. Nomri is having some personal difficulty today.
On premier by the petitioner, not objected to by the respondent. Matters adjourned. Let's see him after 3 weeks.
Bless you, Lordship.
Deeply obliged.
Item number 1.
Pass over.
Item number 2. May I please, Your Lordship? Lordship, this is an anticipatory appeal, Lordship, filed under Section 42 and 31 of the POCSO Act, Lordship. Lordship, in this, what happened, the brief fact of the case is this, Lordship, that there was a relationship between the victim and the accused. They were in a relationship for more than 2 years, Lordship. And then on one day on the 7th, 2025, the victim complained of cold and fever, so the mother took her to the CHC to check for checkup. And on going there, she found out that the victim was conceiving, Lordship. And the mother, that is the mother of the victim, did not want to lodge a complaint, but it was on a compulsion, Lordship, that she had to give a written in writing, Lordship. Now, Lordship, I'll just take you straight to the FIR, Lordship. A plain reading of the
Page.
That I'll be taking, Lordship. That is FIR. This will be page 14, 15, and the translated is on page 16. Now, Lordship, in the
Translated is page 16.
type copy, I mean, Lordship. It is already there. The 17 is the translated. This is a type copy. Now, 17, Lordship, with reference to the subject cited above, I, Srimati Lobilian Marpna, would like to inform you that yesterday, the 06/01/2025, my daughter, namely such and such, 16 years, informing that she is having a cold and taken her to hospital Mawson Ram CHC for taking medicine. But the doctor informed that my daughter is pregnant. Thereafter, on questioning her, she informed that she had a sexual relationship with her boyfriend, namely Lastafil Botte, 21 years, a resident of Plang Mausarpat since April 2024. Now, Lordship, we will see that on a plain reading, there is nothing, no allegation, Lordship. And Lordship, now here, even interestingly, it is the mother of the victim who came forward to file this instant petition, Lordship. She does not want to spoil the relationship between her, between the accused and her daughter, Lordship. That is the victim. So, Lordship, and then there was a notice also. The IO had complied with it, with section 41 of this, Lordship. She had sent the notice that is on the next page, that is page 21. There is the notice, Lordship. And the accused had been complying with this, Lordship. In fact, when they visited the IO also, the mother-in-law, the victim, and the accused They were all together. They went together, and he has been
You're saying
complying.
mother-in-law means are they staying together? They're
Lordship,
married now?
she has accepted, Lordship. The victim's mother has already, she was aware of the
Are
relationship.
they staying together? Are they,
Lordship,
if not legally married, but are they?
Lordship, they are not married, but they are staying together. They were, and she has already accepted that.
In the same house?
Victim in the same house, Lordship. She does. That is why, Lordship, she does not want to spoil the relationship. And Lordship, the accused is an orphan, and his relatives are distant relatives, Lordship. That is why she had come forward for this, Lordship.
Yes, Mr.
It looks like maybe
16 years.
16 years.
Lordship, I may just be allowed to one more submission, Lordship. Lordship, in fact, her age is 17 years, and that is why, Lordship, I'm placing this judgment.
16,
which
17, 15 doesn't matter. 17.11 doesn't matter.
Yes.
Lordship, that is why I'm placing this judgment, Lordship. Lordship has already passed many judgments in it.
It's consideration of certain facts. But anyway, generally, you had appeared before the IO on,
Yes, Lordship.
on receipt of the notice.
Lordship, yes, Lordship.
What is the report of the IO?
The
What did he say?
Lordship, the IO was reluctant to arrest him. That's why because they had come forward, and now even the IO was because seeing the condition of the victim, and then the victim had gone. When she said she would arrest, she would have to arrest him. She went hysterical out there. So looking into that, Lordship, she does not want to spoil the relationship. CD may be called if Lordship is not satisfied with my submission, Lordship.
Mr. Khan, you look at this contents of this notice, page 21.
Page 21. 21.
See, the observation here is, although you are not being placed under arrest at this stage, of course, he has to comply with all this.
Absolutely, Lordship is correct, yes.
Now, thereafter, what would be the opinion of the IO? Report has to be filed.
Report is to be filed, Lordship, yes.
Whether he
complied with all this condition, yes.
compliance with this condition or not, whether he intends to, whether she, rather the IO, intends to arrest him or not.
Yes, Lordship is correct.
Because that would, affect the issue of apprehension.
Yes.
If there's no intention to arrest, question of apprehension does not.
Nothing survives, yes.
This petition,
Absolutely. Becomes infructuous.
Yeah,
Absolutely.
but if there is,
So no, we'll file a short report, Your Lordship, based on this.
otherwise, if you have no objection to the preamble, that's up to you.
Lordship, but this interim may be given. It's in the anticipatory. And we'll try to satisfy this part only. If once we satisfy this, then the matter becomes infructuous. He's only arrested. If she is having an apprehension, she may be arrested. So some protection may be given.
What, Miss? Snowroom Learned Counsel for the petitioner. Also heard Mr. K. Khan, Learned PP, assisted by Mr. Learned Senior, additional Senior GE. The Learned Counsel for the petitioner submitted that an FIR was lodged by the complainant therein, was lodged before the FIR before the officer in charge, Mawson Ram Police Station, East Khasi District, on 7/1/2025, wherein the informant therein had intimated the OC of an incident involving her minor daughter, who is said to be in a relationship with one Shri Lasterpil Borthew, and as a result thereof, the minor daughter had become pregnant, which she had to be taken to the hospital for the necessary examination, medical examination, and thereafter the said FIR was filed. However, it is the submission of the Learned Counsel that the relationship between the alleged victim and the accused person is one of a romantic relationship, and they are also now staying together in the home of the informant herself. Next. Interestingly, it is the informant who had preferred this petition on behalf of the said accused, on the ground that she does not want the relationship between her daughter and the accused person to be affected Next, it is the further submission of the Learned Counsel that in the meantime the IO, upon registration of the said FIR as what? Mawson Ram PS case number 1 under bracket 1 of 2025 under section 5 J2 small Roman 2 oblique 6 of the POCSO Act, had issued notice under section 35 under bracket 3 BNSS requiring the attendance of the accused person. In the said notice, certain condition, though the IO had indicated that the accused will not be placed under arrest at the relevant point of time. However, he has to comply with certain conditions put therein. At this point of time, Mr. Khan, Learned Counsel, Learned PP, had submitted that the IO may be directed to file a status report as far as the investigation is concerned. Particularly the follow-up of the said notice under section 35, bracket 3. In the meantime, the accused person may be allowed to go on interim bail with relevant conditions. This court, upon consideration of this submission made and on consideration of the and taking the on consideration of the submission made at this point of time is in agreement with the submission of the learned PP, and therefore hereby directs the IO to file a compliance report, status report on the next date fix. In the meantime, a status report as well as the CD on the next date fix. In the meantime, the accused person named here and above is allowed to go on interim bail on condition that he shall not abscond and that he shall cooperate with the IO as and when required. How soon?
10 days, Lordship.
We'll fix it on 6.
Okay.
6.
Okay, Lordship.
List this matter on 6.
Highly obliged, Lordship. Item number 3.
Lordship, this is an appeal filed by the claimant. The claimant case has been dismissed by the tribunal after about 10 years on the ground that the deceased died due to his own negligence. There were 5 issues, Your Lordship, which were framed. The learned tribunal has taken up only one issue, that is the issue of negligence, and without deciding the other issue, dismiss the claim application here, which is very rare. The court has taken a very hyper-technical view of the question of negligence, and after 10 years said that nothing is payable to the widow and 4 minor children, Your Lordship. It's very pathetic. At least during my career of dealing with MAC cases, we never dismissed any case on the question of negligence. If at all some negligence is found, some percentage, even we offered that some percentage may be deducted, 25% or so. But tribunal has attributed the entire negligence on my part, Your Lordship. I was driving a Maruti car coming from Barnihat to Shillong side. At Nongpo, there was a head-on collision with one truck. And in that accident, the deceased husband of the claimant died on the spot. And police has registered only a UD case, did not collect the full address of the offended vehicle, did not arrest the driver. Driver of the truck ran away, and they registered only a UD case and sent the report to the Nongpo court. The additional district magistrate at that time did not accept the UD report, a UD case FR, and directed the police to register a regular case. Despite that direction, the police has registered a regular case against the deceased driver. No case can be registered against a dead person. And they never bothered to arrest the driver of the truck or even to take his statement, and they remain ex parte before the tribunal. Only the insurance company was.
Any finding on contributory negligence?
There is no finding. No finding.
Any issue framed?
A issue was framed on the question, on the main issue whether the deceased died. Your Lordship, I'll just take to the impugned judgment.
Anyway, Mr. Jindal, any delay?
Pardon?
Any delay in filing this appeal?
No delay. No delay.
Appeal is admitted. You take steps for issuing notice.
Yes, Lordship, only the thing that address collected by the police in respect of the owner and driver is totally inadequate to serve the notice.
But
And here, one thing more is there, Your Lordship will find that the right of defense of the insurance company, Your Lordship is aware, is limited only under section 149(2).
no, but
Here they have filed an application for under section 170 to take over the defense, but the tribunal has rendered no order on that.
no, but what, has the matter proceeded ex parte against the
Against the owner and the driver of the truck. And we have served only through the publication of the paper. Now the claimant has been fighting from the last 10-11 years this case, Your Lordship. Now serving again.
Then you have arrayed them as a respondent, so you have to take steps.
No, we'll of course take steps. We'll take
We'll
steps.
see how it goes.
Let's see. Just give us only 2 weeks time. Bigger.
Heard Mr. K. Jindal and Senior Counsel appearing along with Mr. Counsel. This appeal is preferred, being the appellant being agreed by the judgment and order dated 6/12/2024, passed by the learned member MACT East Sales District in MAC case number 21 of 2014. This court, on consideration of the submission made, hereby admit this appeal. The appellant is directed to take steps for issuance of notice on the respondents. The same returnable within 2 weeks. This is the matter thereafter.
You call for the records, Your Lordship. We, speedy disposal.
In the meantime, the records of the said MAC case number 21 of 2014 are hereby directed to be produced before this court.
I'll use this.
Item number 4. Your Lordship, I pray for some more time to file my rejoinder. And
All the respondents have filed their
Respondent number 2, Your Lordship.
Respondent number 3 and respondent number 1 we have filed.
Respondent number 2 will, we already prepared the affidavit, but we'll file after 2 weeks. Your Lordship.
Respondent number 2 are required to file a counter affidavit, my lord, as per the previous order.
We'll file after 2 weeks. Your Lordship.
How many respondents are there? Only
3.
Here are 3 respondents. Respondent number 1 and 3 has already filed our counter affidavit, to which the rejoinder is awaiting, my lord. At the same time, respondent number 2, who
yet to file.
My lord, they were not appearing at the initial stage. There was change of counsel, so there was a delay in their affidavit. So they are also paid for time.
Or this newly implemented respondent.
My lord, yes, there was a change in the name of the counsel because there was some difficulty. So that is why I believe there was a difficulty in there.
Mr. Counsel for the petitioner has submitted that the rejoinder to the counter affidavit filed by the respondent number 1 and 3 respectively could not be filed today and has sought for some more time for the same. Allowed. Then counsel for the respondent number 2 has also made similar prayer as far as the submission of the counter affidavit on behalf of such respondent is concerned. On prayer made, list is met up to 3 weeks.
Item number 5.
May it please, Lordship. Lordship, we have taken steps to issue notice on respondent number 2 as per the direction of this Honorable Court. The track consignment report shows that, Your Lordship, the notice has been returned back, Your Lord, unserved, my Lord, to respondent number 2.
You have to get the proper address and confirm the proper address,
Yes, Your
correct
Lordship.
address, whatever the case may be, and
We'll take one more step, Your Lordship.
take some. How many respondents are there?
Lordship, there are 2 respondents, my Lord. 3. There are 3 respondents, my Lord. Respondent 1 has entered appearance already.
And who's respondent 3?
Your Lordship, respondent number 3, against respondent number 3, Your Lordship, we have filed an affidavit of service stating that the respondent number 3 has refused to accept notice, my Lord. So on that behalf, we have already filed an affidavit of service.
So now we are only on respondent against respondent number 2.
Number 2.
Mr. Mayor, counsel for the appellant has submitted that the notice issued upon the respondent number 2 has returned unserved. It is submitted. It is prayed that some more time may be given for the correct and proper address to be ascertained and for issuance of fresh notice. We allow. This is matter up to 3 weeks.
Highly obliged, Your Lord.
Item number 6.
Lordship, the petitioner has preferred the SLP before the Honorable Supreme Court, and it was listed for hearing on the 17th. And now Honorable Supreme Court was pleased to pass an order where the SLP was dismissed. But however, the direction which was issued in paragraph number 27 of the impugned judgment and order passed by this High Court
Where is the
in the yes.
copy? If you are referring to some papers, you should at least give the court a copy. Yes, tell me.
Your Lordship, I pray if this matter will be taken at the end of the board, Your Lordship.
Then finish.
Yes, Your Honor. The order dated 18/6. (18/6/2024) passed in contempt case number 65 or 2022. The Honorable Supreme Court, however, set aside the direction issued in paragraph 27 passed by this High Court for paying the cost of 20,000.
Where is that? Where is the impugned order?
Page 11. Page
It's
11.
on page, relevant portion is to page 21.
So effectively, as far as the contempt matter is concerned, you have no case.
Yes.
As far as cost is concerned, you are not required to pay cost.
Yes.
Matter ends there. Heard Miss Director Counsel for the petitioner who has produced, who has submitted that the petitioner. Yes, Mr. Dr. Musga, anything?
But only the cost part has been set aside.
So, like I said,
So this matter ends, my lord.
Matter ends.
Well,
Kunung Tungo. Being aggrieved by the order passed by this court, the order dated, where's the impugn order?
Page 11.
18/6/24, my lord, order dated.
18/6/2024.
Past, page 11. Passed in contempt case number 65 of 2022.
Had approached the Honorable Supreme Court for with the prayers made therein. However, the Honorable Supreme Court, on consideration of the matter, had by order dated 17/12/2024 declined to interfere with the impugn order, the impugn judgment and order aforementioned. The Honorable Supreme Court, by the said order dated 17/12/2024, had at para 3 of the same set aside the direction issued by this court in the said order dated 18/6/2024, the direction issued at para 27. Oh. It may be mentioned that at para 27 of the said order dated 18/6/2024, this court had directed the petitioner to make payment of costs of rupees 20,000 in favor of the Shillong District Bar Association. The learned counsel for the petitioner has submitted that in effect the petitioner herein is now exempted from payment of the said costs, irrespective of the fact that the said order dated 18/6/2024 as a whole has not been interfered with by the Honorable Supreme Court. Dr. N. Muziga, DSGI, appearing for the respondent contemptors, has submitted that in view of the order of the Honorable Supreme Court, Supra, this matter is now, this matter can be disposed of at this stage. Accordingly, on consent by the parties, this petition is hereby disposed of in view of the direction, in compliance and in view and in compliance with the direction of the Honorable Supreme Court in the said order dated 17/12/2024. matter disposed of. The Ashwai I the set order of the set order of the Honorable Supreme Court. Copy of the set order of the Honorable Supreme Court has been produced by the petitioner. The same is hereby brought under court and marked as Annexure X.
Item number 7.
May it please your lordship. This matter, the trial is going on, your lordship, and the next date is on 6/2, your lordship.
It will be taken up on. You see, it may be taken up on 13.
Let the matter come on 13, your lordship. 13.
On premium by the parties, this is matter on 13.
Apply, your lordship.
Item number 8.
This is a bail application, my lord, regarding those Bangladeshi nationals. My lord, on the last occasion, my lord has directed us to file an application for impleading Union of India as a party, my lord. So, my lord, we are filing it today, my lord, the application. So, I am praying if this matter can be taken up day after tomorrow, my lord.
Yes, our Dr. Counsel for the petitioner has submitted that the direction of this court
27/12.
by the order dated 27/12/2024 for impleadment of the Union of India as a party has not yet been, could not be complied with, and has already prayed for some time for the same, for this, for necessary steps to be taken. As prayed for, Mr. K. Khan, the PP has no objection to the claim made. Accordingly, the same is allowed. As prayed for, this is matter of the 1 week.
Item number 12. Similar item. 12. Item 8 and 9.
Oh, sorry.
8
8 and 9.
8 and 9, sorry.
same.
Same.
8 and 9 same.
Item number 12.
Come. Who is there? Who is there for the petition? Gustav. That's why I said 12.
This matter, my lord, this is a criminal appeal, my lord. We fix it after a week, my lord.
On prayer made by the. Look at the last direction. You are supposed to compile relevant records.
Well,
Sorry. Can you record you?
Number 1 came in when? What day? This is the last number. Today?